Welcome to the Case of the Week podcast, where each week we break down a recent decision in electronic discovery case law and talk about the practical impact for you and your clients, and keep you up to date on your obligations with electronically stored information as evidence. If you're a litigator, legal professional, or you love the power of ESI as much as I do, this is the place to be. I'm Kelly Twigger, the CEO and founder of eDiscovery Assistant and the principal at ESI Attorneys, with more than 25 years of experience navigating the evolving landscape of litigation and eDiscovery. I'm a practicing attorney, author, speaker, entrepreneur, and now podcaster who works as a discovery strategist and expert for clients at ESI Attorneys and to provide that knowledge to all legal professionals through our eDiscovery Assistant platform. In each episode, we'll tackle a new decision in eDiscovery case law and how it shapes both your litigation strategy and planning for risk mitigation. If you're ready for blunt, actionable insights that keep you ahead of the curve, and maybe a few laughs along the way, this is your go-to podcast. Subscribe or follow now to start embracing the power of ESI as evidence. Hi, I'm Kelly Twigger, CEO of eDiscovery Assistant and principal attorney at ESI Attorneys. Here with you today on our inaugural session of Case of the Week. We wanted to bring our community more information about case law that's happening in the eDiscovery universe and talk about some practical applications of the concepts that are being considered by the courts. So jumping right in, our case is one that came out in July of 2020. This is a decision from Judge William Matthewman, who is a magistrate judge in the Southern District of Florida. So to Judge Matthewman's decision, this is called EEOC versus M1 5100 Corporation. And the key concept in this decision is really the perils of self-collection in eDiscovery. So what happened in the EEOC case? This is an age discrimination case brought by the EEOC based on a termination, based on the plaintiff's age. And in discovery, there were three actual issues that were raised on the motion to compel, two of which were resolved prior to the written decision. The decision was referred from the district judge down to Judge Matthewman for consideration. And ultimately, the case revolved around responses to requests for production. And in response to one particular request for production that were signed by defense counsel, the defendant produced only 22 documents from two interested witnesses. And the plaintiffs objected and wanted to understand better how the defendant had gone about searching for responsive information. So as we have these case law discussions, it's always important to remember that we are limited by the facts that are articulated in the decision. So it is always the case that there are more facts in a case than a judge puts in a decision. And so we can only focus on what is available to us and what the court considers in issuing its ruling. In this particular case, because there were only 22 documents, when the plaintiffs met and conferred with defense counsel told them that he or she did not know how his client had conducted a search for the ESI that was produced. And that was particularly troubling to the court in light of Federal Rule of Civil Procedure 26G. So if you're familiar with 26G, you know that even though as lawyers we've been signing discovery responses forever, the requirements of ESI and the amendments in 2006 really put additional obligations on lawyers with regard to 26G. And those obligations are that we know that every discovery request, response, or objection has to be signed in our own name. And by doing so, we're certifying that to the best of our knowledge, information, or belief, and after a reasonable inquiry, that reasonable inquiry is what's key here, that response is complete and correct as of the time that it's made, and it's done consistent with the rules of civil procedure. So what does that really mean? According to the court here, it means that an attorney has a duty and obligation to have knowledge of, supervise, or counsel the client's discovery, search, collection, and production. And that's really important here because, at least as the facts as they are stated in the case, seems to suggest that defense counsel really relied on their client to find the information that was relevant for the lawsuit and to forward it. And in employment disputes, that's not uncommon. Many organizations have many employment disputes. It's very difficult to engage in discovery fully for all of them. In this particular situation, though, the court's issue is that counsel didn't engage with the client at all in terms of defining the search. So what could they have done differently here to have met their Rule 26 obligations? They could have sat down with the client, done a screen share of email programs, looked at date ranges, made sure you were deciding on specific custodians, specific domains, specific recipients. All those kinds of things would have been ones that would have allowed counsel to engage with their duties to be involved in the process and to supervise the identification and collection of that information. So why is it a problem for the court? Why is the court upset that the client undertook self-collection of their own? In a nutshell, you've got two interested witnesses here who were providing information of their own to counsel. And so it can lead to incomplete productions and potential inadvertent or disclosure of evidence. So allowing the plaintiff or allowing the defendants just to have their client inspect information was not sufficient in the court's view. Now, what is really important here, and I think if you take an opportunity to read the case, and we'll put the public link from eDiscovery Assistant into the chat here and on the event page. And I want you to take just a couple minutes. It's not a particularly long decision, but the way that Judge Matthewman articulates the obligations under Rule 26, the former case law associated with self-collection, is a really great way for you to see the layout of how courts view what an attorney's obligations are with regard to counseling clients on searching for information. This is not a process that has to take very long. We're talking about under an hour to be able to look at information, to do a screen share. And in our current remote environment, we're now well acquainted with the technology to be able to do that effectively. Also, in this case, it's important to note that while the plaintiffs asked for both sanctions, they also asked for the opportunity to inspect the defendant's ESI. The court looked again at the Federal Rules of Civil Procedure and also at the Sedona principles and said that Rule 34 really does not allow for inspection of another party's ESI absent extraordinary circumstances, which didn't exist here. So the court held off on any sanctions and gave defendants another opportunity to produce that information. So what's key here is that even despite multiple delays from the defendant, the judge still gave the defendants the opportunity to produce that information, but will evaluate costs at a later date and sanctions if the defendants do not comply with their obligations under the federal rules. So we talked a little bit about practical takeaways. I think what's key here is that even in an employment dispute, whether you're in-house counsel, outside counsel, whether you're litigation support folks responsible for providing information, you need to be able to document what the efforts were that you made to identify and collect information. And what is reasonable in a particular case is going to vary based on the case, but simply allowing the client to make those decisions without input from counsel is not going to be acceptable. That's a quick overview of EEOC versus M1 5100. Understand your obligations under Rule 26G or your state equivalent, and have a plan for each of your cases. Talk with your client. Sometimes clients are reluctant to let outside counsel engage with them for fear that they're going to collect more data than is needed. That does not have to be the case. Work with them and make sure they understand that your obligations in terms of signing discovery responses require that you supervise efforts to identify and collect information. So that's a quick overview of our case of the week. We're excited to be able to bring this sort of practical application to you on a weekly basis. I'm Kelly Twigger, and I invite you to join us for our weekly case update. Thanks.
Thanks for joining me on the Case of the Week podcast. Tune in next episode as I discuss a new decision in eDiscovery case law and identify the issues you need to be paying attention to and how they can help you do better discovery for your clients and leverage the power of ESI. Be sure to subscribe and leave a review to help others discover the show and be kept in the know on all things electronic discovery. I'm Kelly Twigger. See you next time.